Hello and welcome to Friday Live. I am your host, Strata lawyer Amanda Farmer. We're heading out live this afternoon to the Your Strata Property Facebook page. We're going out to LinkedIn. We're going out to YouTube. How are you all doing this Friday in Strata? I hope you have had a wonderfully productive week. It's certainly been a busy one where I am. I've been in a couple of different places this week. Right now, I'm here in my Sydney apartment. As of a few hours ago, I was not here. I was still in my country home in Mudgee. I am in Sydney for the weekend. Was here last week, was here the week before. I think I'll be back in a couple of weeks' time. So there's been lots of travel for me. I was able to manage a flight today, which is always a little bit easier than doing the long drive. So I'm here, I'm refreshed, I'm ready to go, and I have some time to spend with you talking all things Strata. I'd love to know who is here tuning in live. If you want to post me your hellos here in the comments, I would love to know who is with me so I can say hello and welcome you in. If you are joining us catching the replay, drop me a hello. I'll swing back around and acknowledge you there. There has been, as always in Strata, lots happening. This week in particular, perhaps not so Strata related, but certainly impacting people in Strata. It has been International Women's Day. Wednesday, the 8th of March was International Women's Day. I certainly celebrated. If you have been here earlier on the page, you may have seen my photo posts down further below. I was in Mudgee on Wednesday and we have unveiled a very important bronze sculpture in our main street in Mudgee. It is a sculpture of Louisa Lawson. I have filled you in a little bit below what that is all about and why it is important and why we were celebrating the unveiling of that sculpture in Mudgee on International Women's Day, followed by a gala dinner, which I was lucky enough to attend and caught up with a few people, both Strata and non-Strata related, a few Strata faces there, which was very exciting. But I hope you too, in some way or another, were able to celebrate your International Women's Day. I can see some of you coming on in live saying hello to me, which I love. Marion is here. Hey, Marion, how are you? Saying gorgeous green top. Thank you very much, Marion. I have a few of these tops. Some of you fans, loyal fans, may have noticed that I swap out a few of the same tops in different colors. So today we are green. Thank you, Marion, for that. David is here saying hi. Hey, David, how are you doing? Emiliana is saying, hi, your usual follower from Chester Hill. Good day to you, dear Emiliana. Rochelle is here joining me in the background and supporting us together with Mina. If you're seeing stars, I think Rochelle is taking care of that. Anybody who hasn't come across the stars before, because our page has grown so much and is so popular, Facebook for public pages has a system where if you go live with a video or a live stream, they have an automatic prompt for people to vote, show their likes with stars by donating stars. That's not something that we do or we accept. I do not endorse stars here on the page, but for now we have to manually turn off that setting. So Rochelle and Mina are here with their finger over the button, turning that one off early on in our chat. So let me know if they don't disappear, but they should do for you very shortly. Okay. Who has caught this week's podcast episode? Podcast episode number 352, I think we are up to. This week's episode was an edited version of one of the live chats that we had here around about a month ago. I think it was almost exactly a month ago, second week of Feb. I was sharing both the legal and the practical steps that owners can take to deal with underperforming, or we might say misbehaving, Strata committee members. And as I said in that chat, and you'll hear on the podcast, it's a question that I'm often asked, increasingly so, as our buildings get more complex, as our owners get a little more savvy, a little more educated, and start to understand that they might just be able to do something about committee members who are not living up to perhaps the expectations that owners have of them, maybe not fulfilling their legal functions and duties, maybe not complying with the law, maybe not complying with the building's bylaws. What is it that owners can do to combat that kind of problem? So we talked about that here on live about a month ago. You can catch the replay of that live chat in our video library here on the page. And if you're a member, it is there in your members video library. But the essential part of that chat edited this week into the form of a podcast for you. And that was a request that was made during the course of our chat on that day. Amanda, is this going to be turned into a podcast? Are we able to get the transcript of this chat? Because there's some really valuable material in there. So I heard you, and I did produce that chat as a podcast episode this week. And yeah, that's what happens when we turn these chats into podcasts. We do have a transcript. Transcript for every podcast episode is available under the episode where it sits on our website. If you are not accessing the website to listen to podcast episodes, maybe you're getting them through Apple Podcasts or Spotify or wherever you listen to your podcasts, you might want to head on over to the website to see where all the podcasts are, because that's where you'll get your transcript link and links to any other resources, any other similar recommended podcast episodes that I might mention in a chat. It's all over there at yourstrataproperty.com.au/podcasts. And if you're not getting the podcast delivered to your inbox every week, it is there always by a Thursday, sometimes on a Wednesday, podcast episode every week to your inbox. Then you can sign up to make sure that you are on our mailing list and you're getting that podcast episode each week to your inbox. And you do that also over at yourstrataproperty.com.au. So, few comments under that podcast episode, many comments here on Facebook under that podcast episode, which leads me to believe that it is a popular one. The topic that was being discussed was certainly a popular one when we chatted about it live a month or so ago, and the episode has been a popular one. You'll hear me walk through the legal process for attempting to have strata committee members formally removed from their positions by the tribunal. There is a section in our New South Wales legislation that under which owners can apply to the tribunal for an order. But you'll also hear me say that I have never seen in my career a successful application for the removal of committee members by order of the tribunal. So that tells you something, and I walk through in that podcast episode why I think that might be the case. And with that in mind, also give you some practical tips for how you might otherwise deal with a difficult committee or difficult committee members if it's so hard to get an order from the tribunal. Okay, many more of you coming on in. Michelle is saying greetings from downtown O-Town. Great to see you, Michelle. Thank you for joining us. David has a comment, I believe, on this week's podcast episode. Just moving my windows around here so I don't lose anybody. David is saying, I thought the standard that the tribunal sets is too high. Yeah, definitely something that we discussed in the live chat, David, and that I do mention in the podcast episode. It's a very high threshold to reach for a tribunal to find that a committee member should be removed from their position. And it may not even be enough to simply prove those requirements under the legislation, that there has been a breach of the law, a breach of the bylaws, a failure to comply with duties of committee members. Those are, in summary, the things that our legislation says are required, but then the tribunal still has discretion as to whether it makes that order to remove committee members or not. And we're finding that in at least the reported cases that we've had a look at and cases that I've been involved in, the tribunal is not exercising its discretion to remove committee members from their positions. It's a pretty serious step. It does interfere with the democratic process. These committee members were at some stage elected by their fellow owners to serve in those positions. So to interfere with that process, I think the tribunal rightly sees it as a serious step. I'm not sure if it was posted here on the page or it was in a private message that came after that chat that we had in February. But somebody said to me, no, I've lost my train of thought. It'll come back. Where's my pen? I'll write it down and come back to it. Somebody had quite an insightful comment about, yes, there it is, about committee members being elected, and that the democratic process is perhaps not exactly what's happening in our general meetings when committee members are being elected. What's actually happening is no one else wants to put their hand up and be on the committee. So the people who are filling committee positions are those who want to feel the urge to do it, to maybe contribute to their community, maybe in some communities to take control of what's going on in the community. And it's a little simplistic perhaps for me to say, and maybe for the tribunal to assume, that what is at work here is the will of the majority. It's perhaps rather the result of apathy in the community, and only those who put their hands up end up being on the committee. There's not really an election happening per se. So that was an interesting comment, and I do see, look, that plays out. It plays out in my community from time to time when there may be some difficult items on the agenda that others may not have the time or the energy to deal with. We don't have too many hands up at an AGM filling committee positions. And I hear from the members inside our community all the time about the problem with owner apathy and with people not wanting to serve on the committee. So some communities may end up with difficult committee members who are not actually there because they've been elected by the majority. They're just there because there was a role to fill and they put their hand up to fill it and were unopposed. So thank you, David, for your comment. I trust that you enjoyed the podcast episode. Okay, if you're coming in and you haven't yet said hello, I can see lots of live eyes on us here. Please do pop a comment in and say hello. If you have, I'm going to put this as always dangerous, but I'm going to do it today. Put the call out there. If you do have a Strata question for me that you think the answer to this question would be beneficial for others who are living in Strata. So nothing too specific, too unique to your own situation, nothing that requires too much detail, but a nice broad Strata question, maybe about part of the legislation, how it works, something that you think would be helpful for you to know and for others to know as well. If you want to pop it in, I don't do this very often, but I'm doing it today. If you want to pop it in there to those comments, I think we might have time for me to whip around and answer a few sneaky questions on the sly here, not pre-planned, not previously asked for. If you are here live, you're going to get this benefit of popping your question in there and hopefully having it answered by me, your resident Strata lawyer for this afternoon. I'm going to regret that. John is here saying hi, folks. Hey, John. Nice to see you. Excellent. Okay. I have a webinar coming up next week, next Wednesday. You may have seen some information about this in your inboxes this week. It is a webinar all about this new, crazy, fantastic phenomenon that is AI. AI stands for artificial intelligence. And you may have noticed the last few months, literally just months, since about the end of November, early December, the world has just exploded with talk about AI. And you might have heard this platform mentioned, ChatGPT. Let me know, have you heard about ChatGPT? Are you using ChatGPT? Are your kids using it to do their school homework, their university essays? Are you using it at work? If you're using it, I would love to know how you are using it and whether any of you are yet using it in Strata. Because that's what next week's webinar is all about. It's called Bots in the Block, How Artificial Intelligence is Set to Revolutionize the way that we live and work in Strata. So I have been using ChatGPT. I've been using some other tools, which I'm going to show you, give you a little peek at in just a minute, using some other AI tools in my business, in some content that I'm producing for you guys. And I am quickly getting a very good understanding, clear understanding of how AI tools are going to impact the way that we live and the way that we work in Strata, not just for Strata managers, but for committee members as well. And we are just seeing the tip of a huge iceberg here, and it's really exciting for what we might be seeing into the future. Seeing some Strata questions come on in here now. I will definitely come back around and have a look at those. I will have a special guest joining me on the Bots in the Block webinar next week. The webinar is happening next Wednesday at 1 p.m. That's Australian Eastern Daylight Time. And we're going to run till 2:30. It will be an hour and a half. There's a lot. When I sat down and brainstormed all of the things that I want to share with you, that 1 hour webinar very quickly became a 90-minute webinar. My special guest for the webinar is Daniel Boren of the Microsoft Group. A number of you, Strata managers in particular, will know and love Daniel. He has certainly been a past podcast guest. He's been a past guest here on Friday Live. And he is, as I said in my email today, he is known in our Strata space as a technology evangelist. Always at the forefront, always at the cutting edge, always seems to be the one who knows what's coming and is able to share with us how he's using all of these new tools, AI tools in particular, we're learning about next week, how he's using them in his life and in his business and how you can use them too. So Daniel was the first person who came to mind when I was thinking about bringing on a tech expert for next week's webinar. We're going to talk about why we need to pay careful attention to AI in our Strata space, the limitations of AI, and where it might be a little bit dangerous and we might need to be on the ball. I'll be sharing my guidance and tips with you there. We'll talk about how AI tools can help Strata managers to deliver better services to owners and to lighten the load for overworked committee members. Daniel and I are each going to share with you the specific tools that we are using in our lives and in our businesses to fast track some everyday tasks that we all have to do that we may not enjoy all that much, and how we are able to achieve more with less so that you can do that too. Okay. I can see some comments here about ChatGPT. Before I give you the links to register for the webinar and tell you a little bit more, I'm going to head over there and just tap into, I think John's all over it. John is telling me ChatGPT is the top student so far. Yep. So I'll be interested to know what other platforms you might have tried out, John. ChatGPT is definitely the one that everybody's talking about, and that seems to be the most user-friendly. Maybe that's why you think that's a top student. ChatGPT will always make a better committee member, I suspect. Yes, are you putting your Strata questions into ChatGPT, John, and getting some helpful answers there? And beware of Microsoft Sydney, you're saying, John, and certainly Microsoft with their first forays into AI, and Google as well with their foray into AI. Some of their first tests and first releases have not come out all that well, we've been seeing in the media. So I think we do need to beware of some of these platforms that are first to market. We'll certainly be talking about that. Daniel and I will be talking about that next week. Thanks for sharing, John. I can see that you've got to log off, but thank you very much for sharing there. Okay, webinar details. Distracted by comments, webinar details. So happening next Wednesday, 1 p.m, not here on live, on Facebook Live. It will be a Zoom webinar, and you do need to register for the Zoom webinar. Now, this is what we call a pro webinar. The level of information, education that is delivered at a pro webinar is more in depth than other webinars that you might have been on, even other webinars that I've delivered. I know my webinars are often more in depth than others where you might be tuning in, but pro webinars go even further, even deeper. Lots of practical how-to information, guest experts, Daniel Boren joining me next week, real life examples, and I'm taking you behind the scenes, behind the curtain really, into my own internal office processes, and Daniel is certainly going to be doing the same. Our property professionals can claim CPD points for attending pro webinars, and our pro members get the recording of this webinar banked into their CPD library. So for that reason, our pro webinars are only free for our pro members, but we do offer a significant, about 60%, I think it is, discount on the ticket price for all of our members. So Rochelle and Mina, who are here with me, are going to pop 3 different links into the chat here. First of all is the link for our pro members to secure their free spot on the webinar. Just make sure if you're a member at all, whether you're a pro or a standard member, that you're logged in before you click on these links so that you do get the discounted rates. Pro members register for free with your link. Members, you register at the discounted price of $97 with your link there. As long as you are registered, you will get the recording of this webinar. And if you're not a member, the full price ticket is $227. There is a link here for our non-members to register for the webinar. But here's the thing, don't pay $227. I really don't want anyone paying $227 because you can become a member for just $67. Then you can access that heavily discounted member ticket price, 60% off your non-member price, and you can get not just the webinar, but you can get full access to the entire membership community. So that's our Q&A forum, that's our full library of Strata templates, all of my bylaw templates that are there in the library for you to access, past webinars, and your opportunity to book a 1-hour one-on-one online chat with me where we can work through your specific Strata challenge. So rather than buy the full price ticket, jump in and secure yourself a membership for just $67. Then you'll get the discounted member ticket, and that's going to be your best value option. If you are a property professional, you're a Strata manager, for example, or a building manager, and you want to get the whole team in, you want to get the team on the webinar and inside the membership, then I do encourage you to reach out to me. You can pop a comment here under the video, send me a direct message, or send me an email, and I'll let you know your options for getting the team inside on a pro membership, and you'll get that webinar for free. All right, so there won't be a replay available for the webinar unless you've secured your spot before we go live at 1 p.m. next Wednesday. That's Eastern Daylight Time. There won't even be a replay for sale after the event. So you do need to go on in and get registered using one of those options that you can see here in the comments. Thank you very much, Rochelle and Mina, for popping those on in. Just scrolling back here. Thank you, Julie. Julie's telling me Google's is called Bard and Bing is called Sydney. Yes, that's, John, you mentioned Sydney earlier when you mentioned Microsoft. Thank you, Julie. I had a brain snap. I knew Google was Bard and I forgot what Bing was called. Yeah, it is Sydney. I was listening to a podcast episode about how they each performed very poorly when they were presented to carefully selected media for the media to bring us the very exciting stories of how they were each using AI to deliver their search results, and things didn't go so well. So things to look forward to, but definitely to be very careful of and aware of what the limits of the AI technology are at the moment. Okay. I'll just ask Rochelle and Mina to just moderate a couple of those comments that are coming on through. Just have a look through that list there for me. I have a case to share with you, a New South Wales Court of Appeal case. I'm going to do that in just a moment. No, I'll do that now. I'll do that now. We'll come back around. I wanted to show you a couple of our AI tools, but I'll do that, I think, towards the end if we have time. I'm going to share with you our Court of Appeal case, I'm just clicking the right button so I don't close you. Tempting to click the right button. Okay, we don't get a lot of Court of Appeal decisions in Strata, certainly as far as I'm aware, in New South Wales. But we have one. We have one just earlier this week. I think it was Monday, this decision. The owner's Strata plan number 74232. And what do you reckon that is? Tezel? Somebody who was involved in the case will be here and will tell me how we pronounce that. Tezel. 2023 case, New South Wales Court of Appeal. The orders were made on the 6th of March 2023. Now, this case is all about Section 106 of our New South Wales legislation and whether or not an owner is entitled to claim damages, claim their loss from an owner's corporation where there's been a failure to repair and maintain the common property under Section 106. When our 2015 legislation commenced in New South Wales, it commenced in 2016, it had a new provision in it that we hadn't seen before. And there have been some questions about how this provision operates since that time. And this case, at the highest level, the highest court in New South Wales, has given us some clarity about this provision. The provision that I am talking about, I'm hoping I've got a copy of it here for you. If I, okay, I haven't quite shared the right thing. I'll keep going with the case here. The provision is Section 106, subsection 5, which allows an owner to claim damages from an owner's corporation, claim their loss and damage, are the words used in the section, if there's been a failure on the part of the owner's corporation to properly repair and maintain the common property. However, there's a limitation period. There's a limitation period on that cause of action, and that period is a very short 2 years, 2-year time period. And the question that arose in this case through various levels, first before a single member of the tribunal, then before the appeal panel, and then finally before the Court of Appeal, was at what time does that 2-year period start to run? And when the case was first before a single member of the tribunal, well, I'll tell you a little bit about the case first. There's a really great summary here. We have the link to this case, and Rochelle and Mina have popped it into the comments here for us. This head note, if you ever see a reported case and you see the word head note, get excited, because that means, great, there's a summary of the case, and we don't necessarily have to read the whole thing to understand what's gone on. This is a case involving an apartment building in Bondi Beach. In 2013, the lot owner noticed that there was water leaking into her unit during periods of heavy rain. In 2013, she removed the carpet, she stopped living in the unit on a permanent basis, and the unit has been unoccupied since 2016. She'd attempted to rent out the unit and she had been unsuccessful. I'm calling the respondent she. There's a reason for that. I must have read somewhere she was a she. My apologies if she is not a she. The respondent, the lot owner, started proceedings in the tribunal claiming loss of rent. So New South Wales managers, practitioners will know this is becoming an increasingly common claim, loss of rent because the owner's corporation hasn't fixed the roof or the windows or whatever it is, the common property that's allowing water to come into the apartment, and an owner is not able to live in the apartment or to rent it out. And so there is a loss there. This owner has claimed that loss of rent from the owner's corporation, and the tribunal, when the claim first went before the tribunal, said, well, you're out of time for that because Section 106, subsection 5 says you've only got 2 years to make that claim. You first noticed the water leaking in 2013, and you first suffered your loss in 2016 when the unit was unoccupied and you could no longer get rent from it. The claim was made, she was seeking to recover rent, I think, from November 2018. She commenced proceedings in November 2020 by the looks of it. And the tribunal dismissed the claim, concluding that the limitation period commenced when she first became aware of her loss in 2016. So that's when the rain started. She first became aware of the loss in 2016. Out of time, that's more than 2 years. When the owner appealed to the appeal panel. The appeal panel said, no, that's not the time when the period begins. The period actually continues to run for the duration of the damage that's occurring. So you can have successive periods where the time period begins. And for that reason, the appeal panel held that the owner was still in time and hadn't gone past that 2-year limitation period. The Owners Corporation appealed to the Court of Appeal, and essentially the Court of Appeal said that the tribunal at first instance was correct, and that this 2 years commenced to run in 2016 when the owner first became aware of the loss of rent. That's when the 2-year limitation period commenced, and her claim was brought out of time because it was brought in 2020. So you can see here in these paragraphs numbered 1 to 4, this is where we read what it is that the court found, and these are the findings that are then binding on lower courts and our tribunal in future cases. So this is the crux of it here. The phrase first becomes aware of loss in section 106 refers to the time at which the lot owner was first aware of the kind or type of loss that they're entitled to recover pursuant to the section. It doesn't require that the loss be foreseeable or refer to the particular loss that the owner is seeking to recover. So the lesson here is that for owners in particular, the minute that water leak starts, the minute you start to become aware that there will be damage to your property that may cause you to suffer some loss, to move out, where your carpet is being damaged, where your lot property is being damaged, and you might have a claim against the Owners Corporation to recover that damage, you really need to be aware that time is ticking, and that if this is not something that's resolved within the next 2 years, which I suppose on one view sounds like a short, well, on one view sounds like a long period of time to have water coming into your apartment. I can tell you I work with owners almost every week that are suffering from water ingress that goes for years and years. And these time periods can become really relevant to be very aware of when these time periods commenced. And it can go, 2 years seems like a long time to have water leaking, but it can also go very quickly. And so my advice would be to diarise the date that you first had the water ingress and you were first exposed to a potential loss. Diarise it, put it in the calendar, and be aware that you need to be commencing proceedings within 2 years. Certainly, if you are starting these proceedings or thinking about starting these proceedings, seeking legal advice from a qualified strata lawyer who understands how this section works is essential. These are not the type of cases that you necessarily want to be starting without getting that advice, especially if this time period is borderline. So that is this week's case out of the Court of Appeal, New South Wales, the owners of Strata Plans 74232 and Tezel. We have the link here for you to have a read of it. I think just reading the head note, as I've shown you there, is going to give you some good guidance. But it's given us some certainty where until now there has been uncertainty because of that appeal panel decision about those when that period started to run and whether there were successive periods of loss that were running. Always exciting when we get a case out of our New South Wales Court of Appeal. And when I saw that one pop up, I think I saw it on LinkedIn this week, I made a note to come here and share it with you. Okay, keeping an eye on the time. Sean O'Day's here. Hi, everybody. TGIF. I agree, Sean. Welcome. It is good to see you. Heading back to David and our discussion about Microsoft's Bing and Google's Bard AI, David is saying, if you want to laugh, have a read of the New York Times article where Sydney tells the reporter that it wants to hack computers and spread misinformation and how it loves the reporter. Yes, I didn't read the article, David, but I listened to the podcast. So there is a New York Times podcast, which some of you may have come across. If you haven't, it's a great one to subscribe to for busy people. The Daily. And it is a summary of what the New York Times has been reporting on. And that's where I heard the story, listened to the story about Sydney and what she said to this reporter. Were you laughing, David? I was a little bit terrified. At the room for this artificially intelligent being to come up with what she was coming up with and relaying to this reporter. So a little bit scary there. And this is why these platforms are beta tested and monitored and are not, I hope, going to be let loose on the world until these issues are sorted out. Colin Campbell is joining us. Hey, Colin, just here. Great to see you all. Great to see you here too, Colin. Okay, we have chatted about this week's podcast episode. We have chatted about ChatGPT and artificial intelligence, and you have the registration links there to join us for our Pro member webinar next Wednesday. I've shared with you this week's Court of Appeal decision about Section 106 and the 2-year time limitation on claiming damages. Really important for anyone who is working, advising, guiding owners in that space to be aware of that case. I think it's time to wade back in to these comments and see if anyone, I think a couple of you have taken up my earlier invitation to throw a Strata question out there. Strata question, any question. If you are coming in, I can see some more eyeballs coming in live, and you have a Strata question for me today. We have a bit of time. I'm looking at my clock here. We have a bit of time for some Ask Amanda Anything. Doesn't always happen on a Friday live. If you are lucky enough to be here live and you have a Strata question, general, can help, something that will help not just you but others, you think, so not too specific to your situation, post it on into the comments here and I will see if it is something that we can help with today. Okay, Olivia is saying, hi Amanda, any thoughts about the ruling that the need for an engineer's report for any project over $5,000? It does make repairs and maintenance very expensive. Olivia, is this something, is this in the Design and Building Practitioners Act? Not an area that I jump into very often, but if someone wants to just pop me a yes, a requirement that any work project that's over $5,000 needs a regulated design, maybe, or a sign off by a certified practitioner. It's the first time I've heard about a figure being placed on the work. So let me know if I'm in the right territory there. Yes, it would make repairs and maintenance very expensive. Simply requiring the regulated design for work, waterproofing work, I am aware, is required to have that under the Design and Building Practitioners Act. It is making that kind of work harder to get done quickly and more expensive. In my own building, we are experiencing that at the very moment. So I'm sympathetic to that. Olivia, did you tune in last week when I was talking live from Singapore to Helen Cowell, who was sitting next to me? We were at a lovely hotel bar in Singapore. The replay of that chat is here in the video library. And Helen alerted us to a new fact sheet published by our New South Wales Fair Trading, clarifying what constitutes emergency work under the Design and Building Practitioners Act, and emergency work does not require a regulated design and therefore would be the kind of work that you wouldn't necessarily need an engineer or an engineer's report for, depending on what it was. If your work is emergency remedial work, and the type of work that Helen was using as an example, and there's examples on the Fair Trading website, was patchwork, patch repairs to stop a leak that is happening and that is damaging somebody's home, somebody's lot property. So if your work is emergency work, you may be able to get around that requirement based on that clarification that we heard from Helen last week. Just scroll back down the page and you'll see my chat there with Helen and the links to the fact sheet and the links to her summary article on that particular point. Olivia, you missed last week. Okay, I'm seeing your further comments there, so definitely go out and check last week. And Olivia is telling me that the information came from her Strata manager about some waterproofing work. Yeah, so definitely waterproofing work. Yes, you need to have that regulated design, and that generally means involving an engineer. I'm not sure about the $5,000 $5,000 point. I don't know if that's in the legislation. I haven't looked that closely. But if it's waterproofing work that affects other dwellings, so that generally means waterproofing work on the roof, waterproofing work on balconies where somebody's living below, then you're going to have to follow those provisions in the Design and Building Practitioners Act. So having that qualified practitioner involved. Olivia's saying Flat Chat talked about this at some length. Yeah, I wonder if Jimmy Thompson over at Flat Chat was mentioning that $5,000 figure. I'm going to go and check that one out. All right, scrolling back up, I know there was another question here. We are doing an impromptu Ask Amanda Now. Post your Strata question here in the comments, either on Facebook or on LinkedIn. I know many of you join us from LinkedIn. Susan is asking, if police ask for CCTV or resident contact details, what are the privacy issues for committee members, building manager and Strata in the provision thereof? Thanks. Great question, Susan. I like this one. The short answer to this is, if the police are asking for information, I would caution you against acting contrary to a police direction. This would be one of the rare occasions where it is likely to be appropriate to be giving police access to records. I would be asking, I say that as an introductory summary, but if you were in a position and you were able to ask the police to let you know what the source of their power is, what the source of their authority is to access these records, and they may be able to point you to that. They may have subpoena for material. They may have a warrant to be able to access this material. It's important for you to be shown that, or to be explained, to have explained to you what the source of their power is. We do need to be very careful about releasing information to third parties outside of owners who are otherwise entitled to access the Strata roll and access other records of the owners corporation. So I think if you have a record, and I would suggest a written record of approaching this issue with that level of caution and care, and engaging with the police, and perhaps not simply handing over the material to the constable who comes and knocks on the door, but saying to that person, this is private information, I have a legal duty to only hand this information over in certain circumstances, including when compelled by law. If I'm compelled by law to hand it over. So Ms. Constable Police Officer, can you please explain to me which law is it that compels me to hand this over? Do you have a document that says I need to do this, that I need to hand this over, something that you can give me? Because ultimately I have to answer to fellow owners, to fellow committee members, and I want to be able to make sure that everything I'm doing is in accordance with the law. I'm sure you understand. That's the kind of approach that I would be taking. It's definitely a situation that has arisen from time to time in communities that I've been involved in. I'm just scrolling back down to the bottom of the chat to see if anybody else has an experience in that regard. Rochelle is telling me in our private chat that we have a member call for that. Member calls are things that we do inside our membership, where a member has an opportunity to book in a 1 hour time slot with me and to have a one-on-one, which we record, and then we put that video inside the member library. And Rochelle is recalling, she's got a better memory than I do. We have about 7 years worth of member calls, around about 1 or 2 per month. And it sounds like I've previously chatted with a member about this obligation or not to hand over private information of residents when you're dealing with police. So we might come back around for the members who are here in this community on this page today and post the link to that call so that we can, our members can go and get some more information from there, and I can refresh my memory on what it is that I advise in that call. All right, scrolling back up to acknowledge anyone else who has asked a particular question. I'm just seeing those comments about AI, and heading back down to the bottom here. Yeah, Colin is saying, just on this topic about police, Colin is saying, what about recording in a bylaw the use for police? Yeah, I think that's a great idea. I'm not sure that it's in our act, that if you're compelled by law to produce information, I'm not sure if that's in our section 183 in our New South Wales Strata Schemes Management Act is the section that's about records and access to records. And from memory, it says that section or thereabouts says that an owner or their authorised representative is entitled to access records. The secretary of the owners corporation, who, bear in mind, may not be an owner, is entitled to access records. I'm not sure, I'll go and have a look, if that section says that an owners corporation must otherwise produce records if they're compelled by law. It kind of goes without saying that if you were subpoenaed or there was a warrant or you were compelled to produce pursuant to those legal directions, then you would have to. And so your point, Colin, about a bylaw is a good one, because I often say if it's not in the legislation or it's not clear in the legislation, it's a good idea to pop it into a bylaw. So then your committee members, your secretary, those who are having to respond to these requests can point to that provision in a bylaw and say, well, this is what the bylaw says, how it is that we handle these requests, and I was acting in accordance with that procedure. Good one. Thank you, Colin, and thank you, Susan. I can see your thank you there. Rochelle is on it today. I'm going to assume this is Rochelle. Mina, I know you're there. You're there as well. Rochelle did send me the private chat. You're there as well, helping out, Mina, and thank you. But I think Rochelle has just posted our member call number 73, where we were talking about police access to records and police being involved in buildings. So thank you if you're a member in the community. It's Mina. I'm being told now it's Mina. Sorry, Mina. Thank you for posting that in the chat, and our members can go and tune into that call and get some more information. Okay, I had, once again, just watching the time, I had a, not my own question, but my own experience this week in relation to Strata committee meeting agendas. And I thought that this might be a good one to share with you. We're having a Strata committee meeting in my own community early next week. That's happening on Zoom. We meet about once every month, once every 6 weeks, which I find really helpful for us all to stay on top of things. It's not something that's always happened. We've just started to get really good at that the last few years. And we were putting together the agenda, and there's about 5 of us, I think, on the committee at the moment. And 2 things that I noticed that I wanted to share with you, which might be helpful. Firstly, our Strata manager puts together the first draft of our committee meeting agenda. And it's usually in a format that's carried over from the last meeting or carried over from the minutes of the last meeting. So it forces our manager and ourselves to look through those items and just make sure that everything we said was going to be attended to has been attended to. The Strata manager throughout the month has added any additional items that have come up through email, through correspondence from owners, and they're added into the agenda as new items or as progress on previous items. And that draft agenda gets circulated to all committee members. And the Strata manager says to us, attached is your draft Strata committee meeting agenda. The meeting is next Monday. The agenda therefore needs to go out on Thursday. So we have 3 days notice, which is the legal requirement in New South Wales. Please let me have your comments back by close of business on Wednesday in relation to this agenda, and let me know of any changes that you need. And then every committee member has the opportunity to mark up the document. That's what I do. I mark it up with any track changes, add any additional items, and essentially have a say in what that agenda looks like. And to me, that's very normal, par for the course. That's what happens in communities. I know from hearing from you, from messages in my inbox, from questions in our forum, that doesn't happen in all communities. So it's something that works really well for us, circulating a draft agenda to all committee members with sufficient time before the agenda has to go out for additions to be made, corrections to be made, things to be changed, moved, added. And I recommend that that happens. Otherwise, where you end up at a committee meeting is possibly with one committee member saying, hang on, I had an issue that needed to go on the agenda, or I've actually solved this problem and we didn't need to consider it at this meeting, being cut out of the loop because maybe the strata manager is only communicating with the secretary, or the secretary is just issuing the agenda without communicating with any fellow committee members. It makes for difficult meetings. It makes for allegations of a lack of transparency and disgruntled other committee members, and maybe thinking up ways to apply to the tribunal to have a difficult secretary removed, as we talked about right at the top of this chat. So if you're not circulating your draft agendas, I think that's a great idea. It's what my community does, and we were doing this week, and I thought I'd bring that one here to live for you. And the other thing that we've just started doing the last few months is sending the committee meeting agenda to every owner. Not something that we're required to do in a building that's less than 100 lots, but it is something that we've decided to do so that every owner is able to be up to date and to understand what it is that's going on in the building, because we meet so regularly. There's a lot going on month to month, and owners should, I believe, have the opportunity to contribute to those discussions, to attend a committee meeting if they want to listen to what the committee is talking about on a particular topic. And yes, we have a notice board, and yes, we could just put the agenda on the notice board, and that would be sufficient compliance with the legal requirements. But we've decided that instead, especially when you're having a meeting by Zoom, and there's a Zoom link there to click on for anyone who wants to attend, it is far easier, more friendly, welcoming to send that agenda out to every owner by email. So that is what we've started to do. And it's enabled us to, when there may be an owner who says, I didn't know this was happening, or I wish I could have been included in this discussion, or the committee never said they were going to do this, we're able to go to an agenda, say, well, actually, we did. It was there on motion 3 at the meeting that was happening on the 27th of January, and you received a copy of this agenda to your inbox. So it's unfortunate that you didn't see that, but I'm not sure what more we could have done to bring your attention to it. So I don't see the downside to circulating your strata committee agendas in that way, not just putting them on the notice board, but actually in this day of emailing them to every owner. The minutes of your strata committee meetings absolutely need to be given to, I think is the wording in our legislation, given to every owner. The way you do that is to send it to their address for service. Vast majority of owners these days, their address for service is their email address. Some will have a postal address. And if you are issuing strata committee minutes in a building of less than 100 lots or less, then you do need to be sending those to every owner. Just putting them on the notice board is not good enough. Interestingly, it's the opposite rule for our large buildings. 101 units or more, it's the opposite rule. You have to send notice of the meeting to everyone. You must do that. It's not just a matter of choice, you must do that. And the minutes of the meeting don't need to be sent to anyone. They are sent out if somebody asks for them. They are put on the notice board if you have a notice board, or they are just attached to the agenda of the next meeting. I still can't wrap my head around why those things are different, or how each applies, why each applies that way. But that's the nature of our strata legislation. Okay, we have a few more minutes, and I think we have one more question. Michelle has a question. What's the rule with windows and water ingress? Does the owner pay for window replacement, or does the owners corporation? Great question, Michelle. And what this comes down to is whether or not your windows are common property. If your windows are common property, then the owners corporation has an obligation to repair and maintain those windows, which may sometimes require replacement because the windows are just so old that they can't be repaired, and they do need to be replaced in order for the owners corporation to meet that responsibility. In most buildings, isn't it? In most buildings, the windows are going to be common property. If you are living in a building where the strata plan was registered prior to 1974, it is possible that windows and doors that lead out onto your balcony, I'm sitting in front of just such a window and just such a door at the moment in my apartment here. We're not a pre-1974 though. It is possible that those are lot owner responsibility. And that's because of a change in our legislation around that time that changed the boundary lines of our strata plans. So getting technical, if it's an older building, pre-1974, then you do need to be paying attention to which window is it. Some might be common property and owners corporation responsibility, some might not. But generally, if your strata plan is post 1974, and I think it's actually July, there is a month, July 1974, post that date, then it's very likely that they are all, regardless of where they are, leading out onto a balcony, then they are common property and the responsibility of the owners corporation. Always have a look at the bylaws for the building. And because they may shift responsibility in some way. Maybe an owner down the track has done a renovation, pulled out a wall, pulled out a window, and the window has been shifted to the responsibility of the owner, so the general rule doesn't apply. Good question. Thank you very much for that one. I say I'm sitting here in front of my own windows. These are common property, what I'm sitting in front of here, and my doors are common property. I have furniture now. So I was, this is my apartment that I own. It's a 3-bedroom apartment. My family was living here before we moved to the country. And when we moved to the country, I had tenants in here, just the one set of tenants, I think, over the last 18 months. And when I came to the city, I was renting a smaller, some of you might have seen photos of my little apartment, my small apartment, just a few buildings away, still in Bondi. While tenants were in here, tenants moved out around about Christmas, and I decided that I would take over this space and use it. I was in Sydney more and more often, I'm in Sydney more and more often, and I would use it as my crash pad here in Sydney and my studio, and be able to do nice things like this comfortably here in my own apartment. But it just so happens in the last month, I got myself a roommate, got myself a roomie. Her name is Ruby. She is super sweet. She's young, just in her first year out of home, first year at university. She's studying fine arts at Paddington, and the rental market out there is just nuts. And Ruby and her boyfriend were looking for a place to live, had been looking for months, not having any success, being the young people they are, even though they are lovely, lovely people. And I said to Ruby, I got a room. You're welcome to come and use the room if you don't mind me coming and going and doing things like this. And I've come from Mudgee today, and Ruby's been here for a week or so. And I have plants, and I have flowers. I don't know if you can see plants. And I have soft furnishings, and I have some pictures on the wall. And what was a sad, empty place, because I essentially had my office furniture come over from my second office, it's now nice and homely. And I love it. And maybe one day Ruby will walk in the door and you'll be able to meet her too. So I'm very grateful to have Ruby here, making my second home comfortable and giving me good background. Yeah. And I think they're real. I think they're real plants. She's very clever. I couldn't do that. Thank you very much, everyone, for joining me for Friday Live. It is time. Yeah, it is right on that time for us to wrap on up. I really hope that as many of you as possible can join me for our Bots in the Block webinar next Wednesday at 1 o'clock. It is a pro member webinar, free for our pro members. You can get that 60% off the ticket price if you're a member. And if you are neither of those things, then get a wriggle on and become one of those things so that you can join us for our Bots in the Block webinar. Daniel Boren is our special guest expert. We are learning all about artificial intelligence and how it is set to revolutionize the strata space. Yes, for strata managers, but also for those of us who are living in and are serving strata communities. So I'm going to be playing with lots of AI tools over the weekend, and I'm really excited to bring my findings to you and share some tips with you next Wednesday. We'll be on Zoom. We will not be here. Sorry, we will be on Zoom. Should be here next Friday the 17th of March, and another special guest, not Daniel, different special guest coming to you next Friday the 17th. I'm going to surprise you, I think. It might be a name that you recognize, but I'm going to surprise you with those details later next week. Have a lovely weekend in Strata, out of Strata. I will catch you all next time. Bye, everyone.